Something that is absolutely critical is that the Taliban do not get that seat of Afghanistan at the UN. This is a critical demand of many Afghan women human rights defenders. That was the practice when they were in power in the 1990s.
No one can act with impunity.
These are crimes that are beyond the pale.
We are talking about human beings. We're not talking about numbers.
We need a court. That's as simple as that.
This is Asymmetrical Haircuts, your international justice podcast with Janet Anderson and Stephanie van den Berg. This episode was produced in partnership with justiceinfo.net.
All rise.
Hi, Steph.
Hi, Janet.
So we're gradually building up our kind of stable of gender and international justice podcasts, about one a month, trying to cover the main concepts on the one hand and also trying to understand how they can be applied on the other.
So far, we did Gender Norms Expanding in Conflict, that's episode 108 with Katerina Bussel, and the New Crimes Against Humanity Treaty episode, that is number 112, where we had a discussion with Leila Sadat and Priya Pillai on how that treaty might also impact how gender is seen and litigated in international criminal law.
And today, we've got Karima Bennoune. Hi, Karima.
Hi, it's wonderful to be with you.
Karima is the Lewis M. Symes Professor of Law at the University of Michigan Law School, and from 2015 to 2021, she served as the United Nations Special Rapporteur in the fields of cultural rights.
And I thought about Karima on this subject because she actually wrote about gender apartheid, I think back in 2022. And she really gathered all the arguments for this approach, for this framing. And she also countered some of the arguments against this framing. So we'll make sure we put a link in to that paper.
And we're now talking to Karima, who's more about the systematics behind it and the ideas behind it. But we also have plans for another episode with activists from Iran and Afghanistan to ask more about the campaigning and the applications.
Now, of course, being journalists, we will probably cover some of the current events. But just to say, where we're starting off with is to understand the basics. So, Karima, we thought we'd just provide a tiny bit of context just in case somebody listening doesn't know this. And we call the background bit Stephopedia because it's usually Steph who provides them with her Reuters inimitable summary paragraph that she usually has to provide.
So when we're talking about Afghanistan, which is one of the countries often mentioned when we're talking about gender apartheid, we are now talking about the Taliban regime. They were already in power in the 1990s, and now they are back after withdrawal from US forces in 2021. And according to critics, they are imposing a regime of gender apartheid in Afghanistan, just as they did in the 1990s. This is the only governing group in the world to have systematically excluded most women and girls from education in a territory it controlled in the late 20th century and now the early 21st century.
So, Karima, why did you come up with this idea of describing what we've just described there as actually gender apartheid? Or have really a load of people been used the terminology before you did?
So in 2021, I was at the tail end of my term as UN Special Rapporteur in the field of cultural rights, and I had been very concerned with Afghanistan for many years. I first went there in the 1990s as a delegate for Amnesty International when I was one of their legal advisors. I had worked with the Afghan women's movement. I had worked with cultural workers inside Afghanistan who were involved in trying to reconstruct many of the things that had been destroyed by the Taliban the first time they were in power. So when the evacuations happened in 2021, I wanted to do anything and everything that I could to try to assist with the evacuations of Afghan human rights defenders and women human rights defenders particularly, and with Afghan cultural workers. And so like many people around the world, I worked for weeks at that time trying to assist in that process and basically begged many governments to assist, including with the evacuation of people they'd worked very closely with. And very often governments would come back and say, why don't you go and talk to this civil society group, or why don't you go and talk to another government? So I came away from that experience deeply frustrated by this sort of the international community kind of washing its hands of responsibility, governments just kind of thinking they could walk away from any responsibility for what happened in Afghanistan by physically leaving the country. And so when I started to write about this topic in 2021, what I was specifically looking for was an approach that would talk not only about what the Taliban were going to do, which we had had a very good idea about that because Afghan women human rights defenders told us exactly what they were going to do, but also about how the international community was going to respond and how to hold it accountable. And so the one place I could find a way of doing that was through using the concept of gender apartheid, which I really inherited, and we all did, from women human rights defenders in Muslim majority countries who started using this concept. I was told actually even by one Iranian all the way back at the end of the 1980s and then into the 1990s to describe fundamentalist governments and movements trying to take power in the region. So I, in part, grew up in North Africa, in Algeria. The women's movement there started using this concept to describe what the fundamentalist armed groups at that time were trying to impose on Algeria. And they did this for a range of reasons I can explain, but I know this is already a really long answer. So it's that experience that led me to seek a particular tool that could work in this way. And then I looked back, as I think is always important to do, to learn from the frontline women human rights defenders. And in fact, in the 90s, also some Afghan women had begun using this concept of gender apartheid as well, that others in the region were using. And I saw my job as basically trying to create an international legal architecture to really talk about this as a potential legal concept.
Before we turn back to the legal concept and the intricacies of apartheid as a legal concept, what do you think it is specifically by using the term apartheid that is so evocative and so explanatory? I think when you say women are being discriminated against, it evokes one image. If you say gender apartheid, it invokes another. Can you talk a little bit about that?
So there is discrimination against women, unfortunately, to varying degrees in most countries in the world. It is one of the most pervasive human rights violations in the world, alas. But again, to varying degrees. But gender apartheid is a very discrete, specific phenomenon, and that is the institutionalization of systematic discrimination against women as the form of government. It's the governance model, discrimination as the governance model. So it flouts the UN Charter itself, which requires non-discrimination, including on the basis of sex. And I think it really calls out international responsibility. Other states have a legal obligation to end what is essentially an illegal situation. And that is one of the key things that we can borrow from the important legal framework created to respond to racial apartheid back in the 20th century.
So you're already speaking there about borrowing from this racial apartheid. Is the idea to use this term in order to evoke a different way of seeing things, or is the idea to say actually legally it's something different from just discrimination that happens all over the world?
So my view always of the gender apartheid concept was that it's multi-layered. On the one hand, I think it is an important rhetorical term, descriptive term that explains the scale of the problem. And I think that is a term that we can use very readily now. I think it is, as one of the Afghans that I interviewed in my study on gender apartheid said to me, it's a powerful mobilizing tool. I think we can begin cautiously to use the international legal framework that was created to deal with racial apartheid in a sort of thoughtful, forward-looking way to apply to gender apartheid. So, for example, when I, at the tail end of my term as Special Rapporteur on Cultural Rights, I worked on a statement with other UN experts condemning the Taliban's ban on women and girls participating in sports. And we specifically said that the spirit of the Convention on Apartheid in sports should apply in this situation, even if the letter of that convention does not. And of course, that convention tells us that states should not participate in athletic competition with teams from states that are practicing apartheid in sports. So I think we can learn from that model. If we can actually succeed in codifying gender apartheid, then I think it will be possible in the future to have specific prosecutions for that crime, and that can be hopefully accomplished in the drafting of the Crimes Against Humanity Convention, which the Sixth Committee of the General Assembly has been discussing and we hope will move forward. But there could could even be some other ways of getting prosecutions for gender apartheid under the rubric of other inhumane acts as a crime against humanity, using the Rome Statute of the ICC now. And certainly if we see prosecutions for the crime of gender persecution, which is already codified in the Rome Statute, the possibility of recognizing gender apartheid as the institutionalized framework within which the persecution is occurring. So I think there's all these different layers of the concept, but I want to be clear, for me, it was never just about international criminal law. It was about a dynamic, new, broad-based human rights approach that can effectively help to end apartheid-like practices in Afghanistan.
So why did you hit on gender apartheid and not sexual apartheid, which is also something you could have gone for?
So that is the term, in fact, that we inherited from the 1990s, which was a time when the discussion in the UN began to shift from the term sex, which is used in the foundational standards that we have, the Convention on the Elimination of Discrimination Against Women, the Universal Declaration of Human Rights, the Covenants on Human Rights, and so on. And so there was a move in the 1990s to talk about gender largely instead of sex in sort of human rights debates. And so that is to some degree the term that we inherited. I think there has been increasing disfavoring of the use of the term sex vis-a-vis the term gender in some international human rights discourse. But I want to also flag that is very controversial. And I recognize that that is very controversial. And there are also feminists who believe that we should be continuing to talk about sex. And in fact, there has been pushback from both sides towards the concept of gender apartheid. There are those who clearly oppose it because we say gender apartheid instead of sexual apartheid, which I also think is just comes across somewhat strangely terminologically. But there's criticism from that side. There's also been criticism from the side of people who are working largely under the rubric of gender, perhaps about precisely how we're going to define this and if we're going to define it in, an inclusive way that isn't just about women. My view is Afghan women have enough to contend with. They cannot be the ones who have to solve this broader debate in feminism and in, international law and human rights discourse. And I hope that both those who are working on gender, those who are working on sex, will find that there is sort of common cause here in advancing, this particular issue and enabling Afghan women specifically to confront this practice and not get too dogmatic about the terminology. And, it's not something that I talk about a great deal because I tend to be working sort of on other things. And it's such a charged debate. And I have allies working across the spectrum. I actually believe we should be talking about both gender and sex. And so I use the term gender apartheid, but I have also referred specifically again and again to what is happening to women, although certainly there are very important gender crimes happening, including in Afghanistan, against others, including LGBTQI plus people. And I recognize that as being very important, but this is a very specific set of practices targeting half the Afghan population, about 19.8 million people. And it is sui generis. There is grave repression of women in many other contexts we could talk about, but there is nothing on earth quite like this. Women, actually, it is now unlawful for them to speak in public. Imagine that. They cannot go to the public parks. Imagine that. They cannot work in a country full of war widows. Imagine that. And so what we're trying to do is to name this situation in a way that gives us the ability to explain precisely what is happening and to respond to it. And I think it would be a shame if people let other debates and arguments that may be important in feminism thwart that process. Afghan women can't solve this debate, which is an important debate that we need to have.
You mentioned one of the reasons why you kind of turned to international law, not only because you're an international law professor yourself, I'm sure, but also because it has that part of states' obligations and what states have essentially signed up to. I'm wondering if you could just pinpoint for us, where is gender apartheid? Where would we see it kind of codified in international law? And whether you think that the Taliban will pay any attention at all to international law obligations?
So there are a couple of possibilities for codification that have been discussed. Obviously, the most urgent one is in the Crimes Against Humanity Convention, and we hope that that negotiating process will be moving forward. I think the decision on that, the overall negotiating process for that convention, as I understand it, will be made between now and November. And then when that negotiating process goes forward, hopefully next year and going forward, that states will push for the inclusion of gender apartheid along with racial apartheid, which is already in the draft of this convention. And the great news is that 10 states from different regions have already referenced the possibility of doing this. So there is, I think, some really strong cross-regional support. And there is a wonderful End Gender Apartheid campaign you can find on the internet that is trying to support all sorts of international efforts to lobby in this regard. Obviously, that would be wonderful if it happens, but best case scenario, it will take a few years and it will then not be retrospective. So I think we meanwhile also have to be working along the other track, which is the kind of progressive forward-looking interpretation of the existing apartheid law. And this is how international law has evolved over time, although one has to be very careful in and methodologically sound in how one does that. If there are other possibilities. I mean, some have very ambitiously suggested amending the Rome Statute. I'm a little bit more skeptical about that one, or even perhaps some sort of protocol to the Apartheid Convention, which is still in force. So I don't think we should think of all the eggs being in this basket, but I would say that the Crimes Against Humanity Convention is probably a sort of, I don't want to say once in a lifetime, but it is a unique opportunity in the short term. And I think people need to understand it will be absolutely crushing for many Afghan women human rights defenders, as well as some others, Iranians and others, if the Crimes Against Humanity Convention does go forward, but does not include gender apartheid. So I hope that we can all come together and work to make sure that we have actually a 21st century version of apartheid that ends up in that convention.
But the second part of the question was, does the Taliban pay any attention?
So I think they would pay attention to consequences for them. Obviously, this is not a group that respects international law. It's already in grave violation of many existing codified international legal standards. Many of its members are sanctioned and so on. But when, for example, they would be told that travel exemptions would not be available to them because of obligations of other states and other international actors flowing from the recognition that what they are practicing is gender apartheid, they will care. When something that is absolutely critical is that the Taliban do not get that seat of Afghanistan at the UN. This is a critical demand of many Afghan women human rights defenders. That was the practice when they were in power in the 1990s. When the concept of gender apartheid and the international legal obligations flowing from it, which is that other actors cannot be complicit with apartheid, is used to explain why they cannot have that seat, that they will care about. And so what really matters are these consequences. I mean, the whole point of the racial apartheid framework was not to make apartheid unlawful. It already was. The underlying practices were already grave violations of international law, prohibitions on racial discrimination and systematic racial discrimination. What the legal framework of apartheid added in international law was a set of basically circumscriptions on the responses of other actors. They had obligations not to be complicit with apartheid. They had obligations, if you look at what the International Court of Justice said in the Namibia case, they had obligations to end what was an illegal situation rather than quote unquote constructive engagement with those involved in apartheid, which is what some governments wanted to do back then until they were pressured by the anti-apartheid movement. And we're seeing some governments wanting to follow this same model with the Taliban now. That approach is just leading to more and more restrictions. The Taliban are emboldened. And I think so the key thing from the apartheid framework is to concert the response of the international community and to make sure that that response is consistent with international law.
Now, you talked about possible repercussions, and that's the only way the Taliban will really listen. Some states are now talking about taking Afghanistan possibly to the International Court of Justice under the CEDAW Treaty, which is the UN Treaty for the Elimination of Discrimination Against Women. The Netherlands and Canada has already sent Afghanistan or the Taliban a notice that they are officially declaring a dispute with Afghanistan. So it's a kind of preamble to taking it to the ICJ. Do you see that as a possibility or a good development?
So I very much support what the UN Special Rapporteur on Afghanistan, Richard Bennett, has said, which is that this situation is so dire that no single legal tool or concept alone is going to solve it. And what we need is what he called an all tools approach. And I think this is a concept that women human rights defenders have used, a number of times in the past as well. And so we need a full toolbox. The tool that I am particularly working on developing is gender apartheid, but I see as allies and I strongly support those who are working with other tools. I hope that the ICJ case can go forward. I think it would be potentially very significant. I think there are a number of challenges. One is, of course, that we know from the language of the CEDAW Convention that there is a process of arbitration or requirement of attempts to arbitrate with the government in question before you can get to the International Court of Justice under the Dispute Resolution Clause in that convention. And we've seen in the past in the Democratic Republic of Congo versus Rwanda case, they have taken that requirement of following those steps mandated by the CEDAW Convention very seriously. So that will have to take place first. There are, I think, also needs to make sure that in proceeding in this case, there are no unintended consequences with regard to the recognition of sort of accidental, as it were, recognition of the Taliban as the government of Afghanistan, as opposed to the de facto authorities, although there's some precedent for doing this, for example, the litigation around Myanmar and so on. And someone was recently bringing to my attention, important to look at a U.S. case, Cottage versus Karadzic, about basically how you go after a particular actor under international law without conferring legitimacy on that actor. So I think that can be dealt with. And I think another important issue is, and it's the same thing for the work that I'm doing, the centrality of the consultation of those most affected of Afghan women human rights defenders in shaping the case and the kinds of arguments that are made. But I think it's a great example of showing, the Taliban and in fact, the rest of the international community that we take the international law guarantees of women's equality seriously, that it isn't, as a former special rapporteur on violence against women has criticized, it isn't just sort of normativity without legality, that we take those legal obligations very seriously and that states will seek to enforce them. So I think that's a great option to try. I also very much support the work being done by Azada Raz Mohammed, an Afghan woman lawyer, and her colleagues trying to promote the use of universal jurisdiction to deal with accountability for crimes in Afghanistan, including by the Taliban. So using domestic courts to go after those cases as well. I think that that is critically important. Using all of the treaty obligations. I mean, Afghanistan ratified many human rights treaties, in some cases without reservation. So trying to find creative ways to use that language as well to go after the Taliban. I think basically we use every tool in the toolkit. And when we see that there's a gap in the tools, we make sure that those tools are made available.
Our first rounding up question is there something that you were burning to say to us that we didn't give you the opportunity to say? Is there something that we've missed in this discussion?
One of the things I think is really important is to think about what many Afghan women human rights defenders themselves want and what they recognize as the most helpful description or most accurate description of what they're contending with, and really pay attention to that. And I was struck in Richard Bennett's most recent report, he talked about how after a consultation process with Afghan women human rights defenders, who are of course themselves very diverse, that the concept that seemed to resonate the most with the most of them was indeed gender apartheid, because it reflects the ideological nature of what they are experiencing. It really surfaces the political nature of these practices, that this isn't just a question of, Afghan religion or Afghan culture. This is the sort of fundamentalist political ideology of the Taliban. And in that philosophy, sort of the subjugation of women is central. And therefore, I think that is why so many of them have identified with this concept of gender apartheid. And I think we really need to have an international law that is really influenced by and responsive to the experience of those on the front lines. That's this 21st century international law that I've been talking about. And I think international lawyers need to see themselves not as gatekeepers of the 20th century version of international law, but as those who can build on what was important that we inherited, but identify what we need going forward. And when it's not available, help in the process of building that instead of being the ones telling women what they can't do. And this is a very important vision of international law to me when I think about how we move forward on gender apartheid.
One of the other questions we ask our guests now as a standard question, because we're all legal geeks and we get a lot of experts on, and you are an actual professor of international law, so you also teach this stuff. Is there a favorite court case or case that you keep returning to that you like to talk about or that keeps coming up in your work?
I guess with regard to this work, I would say that it's really the Namibia advisory opinion before the International Court of Justice. And one of the things that was so important about that was that despite the fact that South Africa, the government of apartheid South Africa, also was attempting to justify racial apartheid in religious and cultural terms at times, the International Court of Justice clearly saw that as entirely irrelevant. You know, the reason for the apartheid practices was irrelevant and certainly was not going to provide a justification. And that is something, for example, that Courtney Howland, feminist scholars like her, have pointed to as a key signpost for the way in which we should also reject cultural and religious justifications for practices like these when they are directed against women. When I used to be the special rapporteur on cultural rights, I used to say I should have a T-shirt printed that says, cultural rights are core to the human experience, but they are not a justification for violations of other human rights or for discrimination or violence against anyone, because, there's a lot of misunderstanding about that. And so I think the Namibia case, for many reasons, but in particular for that reason, is one that in this work really stands out to me. Another one would be the Akayesu case, which is the case I'm sure you know well, before the International Criminal Tribunal for Rwanda, which is such an important case in a number of ways. One is, of course, that it recognizes that rape can be a way of carrying out a genocide, even though we know that the Genocide Convention does not specifically reference rape or sexual violence as a reflection of the time in which it was drafted, important convention though it is. And the International Criminal Tribunal for Rwanda looked at what Rwandan women had actually experienced during the genocide and had the courage to interpret the Genocide Convention in a gender-inclusive, forward-looking way. And though it's not an exact parallel, I would like to say that I think it would be really wonderful to see the international criminal courts that we have and other relevant courts being as courageous when we start thinking about what apartheid should mean today.
And our final question that we always ask our main interviewees is there anything that you've been watching recently, listening to, or reading that you would like to recommend to our audience? It can be something within this field, or it can be whatever you're using to get away from this field.
I will confess I lately have been very distressed, as I think so many of us are, by the war in the Middle East. And I have found myself gravitating in particular in recent weeks toward music from Lebanon that was very meaningful to me when I was younger and when I had the opportunity to visit Lebanon when I worked at Amnesty International. The music of singers like Fayrouz, singers like Marcel Khalifa, who wrote about earlier parts of the conflict in Lebanon, and just reminding me of how much is being lost and how much is, worth working to save in that region. I think all too often we unfortunately think of civilian casualties in some parts of the world as just the sort of so-called third world body count, and we forget about the human reality that it represents. And so that music has both been a source of comfort because it's incredibly beautiful, but also a reminder of the need for international law to be applied.
Yeah, thank you so much. And thank you also for ending on that lovely note about the music. I will dip into some Lebanese music and listen to some of the recommendations. Thank you.
Thank you so much, Karima, for making the time today and really helping, I think, to lay out some of the basics for us.
Thank you so much. I really appreciate your interest in this topic.
This was Asymmetrical Haircuts, your international justice podcast, created and presented by Janet Anderson and Stephanie Vandenberg. This episode was created in partnership with justiceinfo.net, an independent site covering justice efforts for mass violence, and with the Hague Humanity Hub. Music is by autonautics.com. You can find show notes and everything about the podcast on asymmetricalhaircuts.com. This show is available on every major podcast service, so please subscribe, give us a rating, and spread the word.